Mr. Fischer, can you hear me?
Yes, Your Honor, I do have a hearing running a little long in another county.
Already, we've got a lawyer juggling cases in 2 counties. That's the life of a defense attorney running from courtroom to courtroom, hoping judges don't lose patience. Ever wonder how that impacts the person on trial? Let's find out.
Almost done.
All right, so I can wait, that's fine. So then I'll just wait and I guess pop back over or show your face when you're ready.
Yes, Your Honor, it should be done in less than 5 minutes.
All right, thank you. All right, Mr. Fischer, you're ready?
Yes, Your Honor.
All right. We will go on the record in the matter 25 CM81, State of Wisconsin versus Jenna Sanite. The state appears through District Attorney Kevin Schmidt in person. Ms. Sanite appears in person. Her counsel, Zachary Fischer, appears by video conferencing. We're set here today in this matter for a plea and sentencing. Before I proceed, Mr. Fischer, is this proceeding as such?
Yes, Your Honor.
All right, Ms. Sanite, you see over there on the left on that big monitor, that's your attorney. At the last hearing, I believe you indicated that you were okay with him appearing by video conferencing. Are you still okay with that?
Yes, Your Honor.
Do you understand you have the right to say, you know what, Judge, I want to have a hearing with him here next to me?
Yes, Your Honor.
If at any time you have any questions or concerns and you need to speak with him, let me know. I'll stop the hearing and either I'll send you to our Zoom room to have a breakout session with him, or you can give him a call, okay?
Okay.
All right, so the parties have reached an agreement. I do have the plea questionnaire waiver of rights form in my file, and it is properly signed. Thank you, Mr. Fischer.
Here's the deal. Plead guilty to 1 count of battery, and in exchange, probation instead of jail time. Sounds like a win, right? But hidden inside that probation is a landmine. If she slips up even once, the withheld sentence could drop like a hammer.
And Mr. Fischer, can you please recite the agreement for the record?
Yes, Your Honor. So Ms. Sanite will plead to count 1, battery as a party to a crime. Counts 2 and 3 will be dismissed and read in. And then there will be a joint recommendation for a withheld sentence for 1 year of probation. Conditions to include absolute sobriety and an alcohol and drug assessment and any follow-through as recommended by the assessment, as well as an apology letter to the victim.
All right, Mr. Fischer, before, and I know maybe are you gonna tell me in the arguments if she has a criminal history and what for?
Yes, Your Honor.
Excellent, thank you. Okay, so Ms. Sanite, I don't see that you have the plea questionnaire waiver and rights form in front of you. Do you want a copy or do you remember all that you went through?
I remember it.
Okay, and so I have that in front of me. And did your attorney go over this with you thoroughly?
Yes.
Did he essentially go over it word for word?
Yes, Your Honor.
And so you understand everything completely?
I do.
If you didn't understand something, did you ask him to explain it?
Yes, I did.
And he did so?
Mm-hmm.
Is that a yes?
Yes.
Thank you. Are we in victims' rights compliance?
Yes, Your Honor.
All right. Okay, so he explained everything to you. You understand it completely. And then is that your signature on that second page?
Yes, Your Honor.
It states that you were pleading guilty to 1 misdemeanor count of a battery as a party to a crime.
Notice the judge carefully asking about mental health. That's not just small talk. If a defendant can't fully understand what's happening, the whole plea could be tossed out on appeal. Judges have to make sure the record shows the defendant is competent, crystal clear.
You're 25 years old. You have 12 years of schooling. You can read, write. You understand the English language. You have not had any drugs, alcohol, or other medications in the last 24 hours. Is that correct?
Yes.
You are receiving treatment for a mental illness or disorder. Is it something that will interfere with your ability to comprehend or understand what's going on?
No.
Okay. Did your attorney go over with you what the state would need to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that document. Did your attorney thoroughly go over those rights with you?
Yes, Your Honor.
Do you understand them completely?
Yes.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
All right. Here, the state would have to prove for misdemeanor battery as a party to a crime that on or around April 27th, 2025, in Burnett County, Wisconsin, as a party to a crime, you caused bodily harm to KRB by an act done with intent to cause bodily harm to that person. Do you understand what the state would need to prove?
Yes.
Do you understand what it means to be a party to a crime?
Yes, Your Honor.
Do you need me to go over that definition?
No.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or 9 months of incarceration or both? Do you understand that?
Yes.
Do you also understand that the parties have reached an agreement, as recited on the record by your attorney, for 1 year of probation with what's called a withheld sentence? And do you understand exactly what that means?
Yes.
And do you also understand that I'm not bound to follow that recommendation?
Yes.
So if I thought the facts of this case warranted it, I could sentence you all the way to the maximum possible penalty. Do you understand that?
Yes.
Do you still wish to proceed?
Yes, Your Honor.
Do you have any questions for your attorney?
No.
Okay. Did you go over the criminal complaint with your attorney? And that's that original document, and it has a section in there called the probable cause section that basically says what happened that day and why you were charged with crimes. Do you remember that?
Yes.
And you don't have to, I'm not asking you if all of the facts are 100% accurate, but for the most part, are those facts accurate?
Yes.
Mr. Fisher, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Are you admitting to guilt because you're guilty of this crime?
Yes.
Okay. Has anyone made any threats or any promises to you for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he looked to see if you have any?
Whoa, here comes the ugly truth. Not only was the victim assaulted, she was nude and filmed during it. That detail, it cranks the humiliation factor through the roof. Prosecutors highlight this to show just how vulnerable the victim really was.
Defenses or a lack of defenses in this case.
Yes.
Are you satisfied with the services?
Yes.
One last time, any questions for the court or for your attorney before I proceed?
No, Your Honor.
As to count 1, misdemeanor battery as a party to a crime, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1, counts 2, and 3 will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you, Judge. Just one change to the recommendation. We're not going to be asking for an apology letter. The victim affirmatively said she doesn't want that. So I'm not asking for that anymore. I do think that the 1 year probation is the way to go in this case. Ms. Sanite has 1 prior conviction. It's for an OWI offense in Minnesota the offense was in 22, but I think the conviction actually happened in 23. In this case, there was video evidence. You could see that the defendant was intoxicated in the video. I think that's why I really want the AOD and follow through here. This shows that really profound alcohol abuse issues, that she behaved in the way she did. Essentially what this case is she went to her boyfriend's home. He was with another woman who was nude.
Classic defense strategy here. Admit the wrongdoing, but redirect the moral blame. Instead of saying she's innocent, Fischer argues, yeah, she messed up, but the real villain was the lying boyfriend. Smart move, it humanizes the defendant without excusing the crime.
The boyfriend admitted to law enforcement he had lied to the victim, KB, and told her that he was single. Regardless, the defendant attacked the victim instead of her boyfriend, though attacking the boyfriend would have been also criminal. It just would have been less morally culpable than attacking this person. Her friend filmed it. It was a really the victim was particularly vulnerable because she was nude during the assault and being filmed during the assault. For that reason, I think that this isn't a case, even though this is, second offense. I do think the probation's necessary here because there are some alcohol issues that I don't think were adequately addressed with the Minnesota OWI that need to be addressed here if it would drive now to violent behavior. Thank you.
All right, thank you. Mr. Fischer, argument and sentencing recommendation, please.
Your Honor, I am going to ask that you follow the joint recommendation here today. In terms of the facts of this case, I understand they are pretty severe. Ultimately, the victim was there is really no excuse for the actions in this case. I do understand, and I've discussed with Ms. Sanite that the circumstances were certainly not good by any means, or I don't expect or really anticipate anyone under those circumstances would be anything but upset. But I think in her plea today, I would argue designates that she understands that her actions that day were wrong and unacceptable, and that if anything, again, not that she should have done anything to the boyfriend, but her anger should have been directed towards him rather than towards the other victim, who was also unknowing to anything that was going on at the time. I would ask that you follow the joint recommendation in that she does not have any violent history. This is her first offense where she is admitting to causing harm to another person. The prior OWI offense, while it is still criminal, it is not a violent offense. And I do believe that probation in this case would be appropriate in the withheld sentence, given the ability for her to serve up to those maximum penalties on the battery charge if she was to not follow through with maintaining her sobriety and trying to follow through with any alcohol treatment that may be recommended in this case. As I do agree, if alcohol was not involved, that Ms. Sanite maybe would have been able to have a better head prevail and not have lashed out in the way that she did. For the reasons that she is young, she does not have a lengthy criminal history, she does not have any prior violent offenses. I am going to ask that you withhold sentence and place her on probation here today.
Thank you. Ms. Sanite, do you have anything that you want to say to the court? You don't have to, but it's your only time to let me know anything from your side, for you to let me know anything that you heard that may be incorrect or not exactly on point.
No,
like
Your
to say
Honor.
anything? Okay. Do you have children?
No.
Okay. Well, that's good because you're 25. You have your whole life in front of you. Children are great, but you're 25 and you could do so much more with your life. I don't know what you're doing. Are you going to school?
No.
Are you working?
Not currently.
Do you have a plan?
Yes.
What's your plan?
I would like to return to work.
What kind of work?
I cook at a bar.
Okay.
Yeah.
Do you have any future goals or plans that you would like to do?
This is where judges switch roles from stern authority to life coach. Notice how she talks about jobs, school, and goals. It's part warning, part pep talk. Judges often remind young defendants, one bad relationship isn't worth throwing your entire future away. Can you feel the shift in tone here?
I would like to work in healthcare again.
Okay. That's good. That's a lot of work, being in healthcare. But it's rewarding. I'm glad to hear that. I'm really hoping that you work towards that. You're 25. You're such a young lady. This is a serious offense because you went to your boyfriend's house. I hope he's not your boyfriend anymore. Good. I'm glad to hear that. You went to your boyfriend's house, your ex-boyfriend's house. He was with, I believe, KRB was an ex of his, if I recall correctly. And you saw them together and you reacted immediately violently. I agree that the true victim here is KRB. If your ex-boyfriend told KRB that he was single, she had no clue that she was doing anything inappropriate. A man is never worth it. Never, ever worth it to throw essentially like your future, your life away for, or to do something like this. Because now, unfortunately, you have a criminal conviction for battery, and you're